All right. Good evening once again, ladies and gentlemen. This is our last chapter of the book, so we're about to wrap it all up. Chapter 15, Counterterrorism. So let's go ahead and start. Well, before we get to that, I know you're wondering why there's a chapter on counterterrorism in a criminal procedure book. It's very important because a lot of laws that were made, I guess, in response to terrorism, um, were actually laws that kind of run awry of the Fourth Amendment. So it's very important. So of course, during 2001 with the 9/11 incident that led to people being cool with essentially giving their rights up and opening up Pandora's box for the government to now kind of look at you and surveil you. And we're also going to talk about the fact that a lot of people have been arrested in foreign countries. People that have never been to America and didn't even commit crimes, or the crimes they're alleged to have committed were not even on American soil, but they were on the other side of the ocean. But these people were pulled from their country, arrested, flown to America and detained, or flown to American territory in Guantanamo Bay, Cuba, and detained. And that they didn't have, so they're detained without rights. At least in the beginning, of course, there were lawsuits filed that changed some of that stuff. So that's what we're going to talk about. That's why it's important. In October 2001, of course, in September 2001, that's when the um, World Trade Centers were bombed. But so a month afterwards, in October 2001, the U.S. Congress passed and President George W. Bush signed the USA Patriot Act. This law was amended by the Patriot Act Improvement Act, which was signed by President Bush in 2006. Electronic surveillance. In 1987, the U.S. Congress enacted the Foreign Intelligence Surveillance Act, or FISA, FISA. Um, the purpose of this legislation is to provide procedures for electronic surveillance and physical searches undertaken to protect the national security of the United States and to combat international terrorism. FISA establishes the Foreign Intelligence Surveillance Court, or FISA Court. The government, in order to obtain a FISA warrant, is required to demonstrate probable cause that the target is the agent of a foreign power, is affiliated with an international terrorist group, or is engaged in international terrorism. Um, FISA warrants are based on a less demanding probable cause standard than ordinary criminal investigations. Um, the primary purpose of the surveillance is required to be the investigation of a threat to national security or the threat of terrorism. This language is intended to eliminate the wall between terrorism investigations and criminal investigations and to permit the sharing of information. The place to be targeted by the surveillance must be used or about to be used by the agent of a foreign power or international terrorist. Pin registers, which is how they keep up with phone calls, like the list of people calling in and calling out, are employed to record telephone numbers dialed by from a phone, and trap and trace devices record the numbers of incoming calls. An application to install a pin register is approved when the investigator certifies to a court that the information likely to be obtained is relevant to the investigation of a threat to national security or to the threat of terrorism. Access to voice and mail, um, and to email requires a search warrant issued by a judge based on probable cause. Roving wiretaps permit the electronic surveillance of all telephones or computers or other electronic devices utilized by an individual without requiring the law enforcement obtain a separate warrant to monitor every phone or computer account or other electronic device that a target may utilize. Electronic service providers are authorized to voluntarily disclose stored electronic communications in an emergency situation. Sneak and peek warrants. Section 213 of the Patriot Act provides for sneak and peek searches. A sneak and peek search authorizes law enforcement to delay notifying an individual that they have conducted a search. That means they can search your home and come in and come out, and you didn't know they were there. The government may conduct covert searches to investigate federal crimes when there's reasonable cause to believe that providing notice may result in an adverse result. Section 219 of the Patriot Act authorizes a federal court with jurisdiction over an offense involving international or domestic terrorism to issue a nationwide search warrant. Information and records. Section 505 of the Patriot Act expands the authority of the FBI to issue national security letters and permits the FBI to obtain access to information when the information is relevant to the investigation of terrorism or secret intelligence activities. The FISA court, under Section 215 of the Patriot Act, may issue orders granting the government access to any tangible item that includes books, records, or other documents in a foreign intelligence investigation or in an international terrorism investigation. A request may be made for a tax return, education and medical records, or records from a library, bookstore, or firearm sale. Detention of non citizens. So, what we just talked about was the ability for them to search and kind of rummage through your things, and at least in sneak and peeks, they don't even have to tell you. They can leave your house the way they found it and walk out. And you get home and not know someone just ran through your stuff. Um, all they have to do is classify you as a terrorist or a possible terrorist threat, and they can do that. Detention of non citizens. The Patriot Act provides that a non citizen may be detained for several days without being charged with a criminal or immigration violation. The U.S. Attorney General must certify that there are reasonable grounds to believe that an immigrant is a terrorist or has engaged in terrorist activities. An individual may be held an additional 6 months if the individual is unlikely to be deported in the near future, and the Attorney General determines that the individual's release threatens national security or public safety. This certification may be renewed every 6 months. Material witness warrants. That means they're now warrants where they can, if they feel like a person is a witness that can help, they can actually go detain that person as a witness, not as a defendant or a suspect. The U.S. Congress enacted a material witness law in 1984 to enable the government to arrest a witness whose testimony is material to a criminal case and who may be unavailable to testify before a grand jury or in a criminal prosecution, or who may flee in order to avoid testifying. Monitoring and attorney-client communication. And of course, the preface for this is that attorney-client communications are confidential, meaning they can't be recorded. And if they are recorded, they definitely can't be used against the attorney or the client. So that there is attorney-client privilege. So um, in October 2001, U.S. Attorney General John Ashcroft issued an order permitting the Federal Bureau of Prisons to monitor attorney client communications where the Attorney General certifies that reasonable suspicion exists to believe that a pretrial detainee or an inmate may use communications with attorneys to further or facilitate acts of terrorism. That means now, when an attorney goes to see his client who's a detainee, now they can record that conversation and use it against them. So it's like really literally no more privacy. And all they have to do is say, hey, we believe this person is a terrorist, and they're communicating terrorist activity to their attorney. Interrogations, and this is a big part. This is where a lot of people, we talked earlier about confessions and interrogations, and how it has to be reasonable and they can't use force and stuff like that to coerce you. Not when it comes to counterterrorism. You'll see. The Bush administration determined that that Al Qaeda was a terrorist organization, and that apprehended members of Al Qaeda and of the Taliban in Afghanistan are not protected under the Geneva Conventions regulating the treatment of civilians and prisoners of war. So, of course, the Geneva Convention was a post-war convention. I want to say post World War II, if I'm not mistaken, where the world powers got together and said, okay, when you're at war with another land, there have to be rules uh, regarding how you treat prisoners of war. So, no torture and no stuff. So, and if torture is used, it can only certain types of torture, essentially, is what they said. So that there has to be levels to what is used, what you can do to a person when they're being detained. Um, so that's and essentially how you treat. It's all about how you treat prisoners of war. As a result, the Department of Justice and Pentagon agreed that various enhanced interrogation techniques may be employed to obtain information that is vital to the protection of the national security of the United States. So essentially, by having these people classified and not included under the Geneva Convention, that meant now they could do what they wanted to do to these people who were in their custody. The United States formally put a halt to these interrogation techniques in the Detainee Treatment Act of 2005. Now, some of that detainee treatment included like waterboarding, beating, stuff of that nature to kind of get information about terrorist threats. So, of course, as we learned in earlier chapters, if a person is being tortured, you're less likely to get the truth from them. You're going to get whatever they say so you can stop waterboarding them as opposed to what the truth is. Um, Section 1001 provides that no person in the custody or under the effective control of the Department of Defense or under detention in a Department of Defense facility shall be subjected to any treatment or technique of interrogation that is not authorized by the U.S. Army Field Manual on Intelligence Interrogation. So you have the Army, who is a product, an instrument of war and killing, determining what can be used. Because we're going to use the Army's manual um, on how we treat opposing parties or people we're fighting against. So you can only imagine how well that went. Military commissions and combat status review tribunals. In November 13, 2001, President George Bush, as Commander in Chief of the United States military, issued a military order establishing military commissions that were to conduct trials of non citizens who are members of Al Qaeda and who are engaged in international terrorism or who have assisted acts of terrorism against the United States. In Razul v. Bush, that was a defendant by the last name of Razul who sued the president because of his detention. The U.S. Supreme Court held that the federal courts possess jurisdiction to consider applications for habeas corpus. We talked about that last chapter. In other words, he uh, applied for habeas corpus to justify his detention. Um, but the U.S. Supreme Court held that federal courts possess jurisdiction to consider applications for habeas corpus from individuals detained at Guantanamo Bay in Cuba who were captured abroad during hostilities between the United States and the Taliban. So what that meant is they were literally overseas in Afghanistan or a Middle Eastern country trying to fight terrorism, and they were taking people off the streets because essentially they were accused of being terrorists or part of Taliban. So they were taking these people off the streets, arresting them, detaining them, and in some situations flying them across the globe and holding them in Guantanamo Bay. Now, mind you, Roswell v. Bush was a case that came after November of 2001. So what that meant was um, these people didn't have any habeas corpus rights. So before this case, Razzle v. Bush, these people were being detained and there was no means of challenging their detention. So they couldn't go to a court. So once Razzle v. Bush came about, that gave them the right to now at least use American courts and appeal their detention or use a habeas corpus writ to have a court look at why they're detained and to determine whether or not it's lawful or constitutional. And Hamdi v. Rumsfeld was the Secretary of Defense in the Bush administration. The Supreme Court held that an American citizen who had been detained in Afghanistan was entitled to a hearing to determine whether he was an unlawful combatant. The U.S. Congress passed the Detainee Treatment Act, which, among other provisions, establishes combatant status review tribunals, or CSRTs, combatant status review tribunals. So that's a tribunal where they can review the status of a combatant that they've taken from another place and they have in their custody. So that kind of gave them a court to be heard. Um, but these CSRTs were used to determine whether an individual was an unlawful enemy combatant. And an individual status then regularly is reviewed by administrative review boards that determine whether an individual should remain in custody. So that means you get arrested in Afghanistan because you're an Afghani citizen, um, because you've been accused of being a terrorist. And let's say, for instance, you're actually not a terrorist. You were just like walking down the street, and you got arrested for being a possible terrorist. They would arrest you and ship you across the globe, um, and you would sit in this terrible jail in terrible conditions. If you think Guantanamo Bay was nice or some lap of luxury, you're sadly mistaken. So you're taken there, and then you go before this CSRT, and you argue that you're not a terrorist. And let's say they say, yeah, you're right, he's not a terrorist. Let's send him back. So even if he wasn't a terrorist before getting captured, he might have been someone that was cool with America being there because he wanted everything to change. What do you think he was going to be after being detained, flown overseas, and held in custody in bad conditions? So even if he wasn't a terrorist beforehand, now after going through all that, how do you think he feels about America? At this point, he probably feels as if he could board a plane and drive it into anything or fly it into a building of any sort in America. Because now he wasn't a terrorist before he might not have been a terrorist before he was captured, but now he hates America's guts. So you see what this can turn into. Um, so in fighting terrorism, we're essentially fighting an idea, and it's the only way to fight against an idea or how someone feels about you is to change your conduct or adjust so that they feel differently. Because you can't really fight an idea because ideas are actually reborn in every time a new person is born. So if I'm a father, I have a kid, and I have an idea, and I place it in them, killing me doesn't kill the idea because now the kid has the idea. And even if I didn't give the kid the idea, the kid's gonna forever grow up knowing America killed my daddy. I hate him. So now there's a terrorist born right there. So it's like, can you ever really get rid of the terrorist issue? I think the real way to take care of the terrorist issue is to change some foreign policy, and show that you really care about foreign policy and what's going on, and that you're not a crook. Okay, let me see. Hamdi Rumsfeld, we talked about that. The Detainee Treatment Act. So even if they were deemed to be not combatants and they got sent back over, they were now probably really American haters at that point. In 2006, in Hamdan versus Rumsfeld, the United States Supreme Court held that the military commissions established by President George W. Bush possessed several fatal flaws. In other words, they were unconstitutional and it had to be changed. Um, uh, President Bush responded by consulting with Congress. The Congress passed, and the President Bush then signed the Military Commissions Act of 2006, which reorganized the military commissions and provided for greater protections to defendants. So, if you're going to take these people from a country and bring them here, at least like give them the opportunity to possibly challenge their detention, and at least don't waterboard them and stuff. So yeah. Um, in 2008, in Boumediene v. Bush, the United States Supreme Court reviewed procedures of the CSRTs. Um, the the courts noted that Congress had suspended the writ of habeas corpus in the Military Commission Act, but had failed to provide an adequate substitute procedure, and the suspension of the writ therefore was held to be unconstitutional. So at one point in time, they actually took away the habeas corpus opportunity, and of course, The U.S. Supreme Court said, no, ho, ho, you got to at least offer an opportunity for them to have their day in court to at least where it can be determined whether they are or are not terrorist combatants. So that's my going through the chapter very briefly, just talking about all the issues of counterterrorism. So essentially, what this chapter shows us is that in fear, you'll be surprised what a person will give up. They'll give up rights. So not in a lot of these rights. Now, the first part of this chapter review, we were talking about being surveilled or having the government be able to just look at you without a warrant, or with a warrant that's not given by any court, but kind of determined in a separate tribunal. So as long as they can put the T word on you, terrorists, it's like, hey, we can just do the sneak and peek. Do you think courts are really saying no at this point with the war going on and this terrorist fear from 9/11? No, they weren't. So this whole terrorist thing could be used as a catchword to kind of uh, make the government and make law enforcement and federal government and the military do certain things. And that's what it was. Terrorist was like a code word for go get them or go violate their rights. But then we moved on in the chapter where we started to talk about what they were actually doing and what was happening to people overseas who were deemed to be enemy combatants or terrorists that weren't even in America. These people were way overseas. Of course, in a war, you're fighting another country. These people didn't want us on their soil, and we were there, so they were combatants. Of course, they wanted to terrorize us and at least get us off their land. So, in doing so, of course, they're enemies. So we were literally capturing these people who a lot of them were civilians and probably not even militarily trained, but they didn't exactly side with America, and they were pro-Afghan, and actually they probably cheered for the Taliban. Um, and Al Qaeda, and they said, in having that viewpoint, you get arrested, and you may not have actually done anything, um, but now you find yourself in Guantanamo Bay, Cuba, far away from home, and you're being held in this military prison. And if they think you have intelligence or know something, they're torturing you to see if you can tell on somebody or tell us when the next attack is going to happen. And let's say, for instance, you're not actually a terrorist. The question is, do they know the difference between who was and who wasn't, or did they just say, "Hey, you're Afghani and you're here. We're going to beat you till you tell us something"? So it's really a crazy area to, it's like, that's kind of iffy to discuss, where people are really being treated fairly, and I think in a lot of situations they weren't. Now, to the credit of the U.S. government, some of these people probably were terrorists. But at least I'm glad towards the end they at least started extending rights to these people so they can at least challenge their detention and be heard and have some type of tribunal to make a decision on whether or not they're guilty or whether or not they're actually enemy combatants. But the risk that we took in that is, let's say if we were wrong and a person was not an enemy combatant or someone that we captured, and when we captured them they weren't enemy combatants, now we find out they're not, but we've taken part of their life. We've flown them on the other side of the earth. At this point, now that this person is seen to be not a combatant, what do we do with him? If we can't really, hopefully not release this person that now has if they didn't have a hatred for America at the time, now they definitely do. We're going to release them into America and let them live hating America. Now they probably are our next terrorists because they're pissed. Or do we let them go back, send them back to where they are, where they're from, or where they were in Afghanistan, and they still land in Afghanistan, being a person that might not have cared about anything before, but now they definitely are not indifferent. They definitely They definitely want to get America back. So like we kind of create our own enemies in certain situations. So that's the weird thing about these things. Now, like I said, the terrorist situation did happen, and it's, I believe it has to be policed, and but how far do they go? As much negative as I may be saying about it, some terrorists got caught, and some plans got thwarted because of some of these actions. So I can't speak everything negative about it, but then you also got to look and say, is that really how we want things to be done? But these people also aren't Americans that have violated laws. These people are in a country where we're fighting in their country, and sometimes in these situations you don't know who the enemy is and who the enemy isn't. So then the question becomes: should we treat an enemy combatant or prisoner of war with the same rights and give them the same rights and privileges as a citizen who may be arrested for something in America? So it's really crazy. Now, I'm not giving you an opinion either way, but this chapter raises a lot of questions, at least in my mind. It did. I was like, wow, like, we gave up some rights. Maybe this means of surveillance might lead to something or protect us, but you'll be surprised what people are willing to give up and what people will be cool with in fear, because they don't want to be the next 9/11 victim. You don't want to get on the airplane and it get hijacked, and now your life ends by being, the plane being flown into a building while you're on it. So a lot of things to think about. But a good chapter, a good way to end. Kind of accomplishes everything, but that ends the book. Of course, at some point in time, I'm going to post a a cumulative review of what we went over the whole class, for the whole class, chapters 1 through 15, talk about it, probably go over writing a little bit again. And then, of course, at some point, go over the final exam and talk about what's going to be on that, but that's going to be in later lectures. So we're going to go ahead and shut it down. That's chapter 15. That's it, y'all. That's the end of the book. So at this point, it's just about assignments. So you guys be good. Take care.